evening. Welcome, everyone, and thank you for joining us tonight. I'm going to turn an introduction over to Jim, and he'll start the program for us. Thank you.
Hello, and welcome to Columbia Memorial Health Foundation's estate planning update for 2022. Before I introduce our distinguished presenter, I thought I might give a brief description of our foundation. We're the sole fundraising organization for Columbia Memorial Health, a member of the Albany Med Health System. Our community hospital is located in Hudson, New York, and we have 41 physician practices in rural communities throughout Columbia, Greene, and Dutchess counties that include primary, specialty, pediatric, diagnostic imaging, and 3 rapid care centers located in Catskill, Copiague, and Volusia. To learn more about our work and to see the many ways that you can support our important mission, please visit givecmh.org. Now on to the reason we're all here, to learn more about estate planning from one of the area's preeminent authorities, Lou Pierro. Lou is the founding partner of Pierro, Connor & Strauss, LLC, and has been practicing law for, I'm sorry to say, nearly 40 years, the majority of which in the areas of estates and trusts and elder law. He's been selected by his peers as 2022 Lawyer of the Year for Elder Law in New York's Capital Region, an honor he's also received in 2018. Please welcome Lou Pierro.
Thank you, Jim. And for those of you that don't know, Jim is a preeminent financial advisor in Hudson, New York. He's also the son of my Boy Scout troop leader and my former doubles partner and an extraordinary singer too, if you haven't heard Jim sing.
Thank you very much.
I want to thank Barbara and Jim for the opportunity and CMH Health for allowing me to present to you tonight. And I hope you're all enjoying yourselves out there. It's 5 o'clock. So, if you want to enjoy happy hour, you can do that. It's a webinar. Provide yourself a refreshment. And we're going to have about an hour to talk about some important estate planning ideas. This is an evolving topic. It changes year to year. So we're going to cover some of the changes from 21 to 22. And also talk about some of the core principles of estate planning that everyone should know. We'll talk about taxes, how to avoid them, what some great techniques are to utilize both philanthropy and tax planning to benefit yourself and your families. And finally, we're going to talk about long-term care. First, a little bit about our firm. Pierro, Connor & Strauss is a law firm based in Albany and New York City. We have a Manhattan office at 260 Madison. We're here in Latham, New York, at 403 British American Boulevard. We also have offices in Hudson, New York, Lake Placid, affiliate office in Utica. We practice in other states, New Jersey, Massachusetts, and Florida. And we have a practice that has grown in the business succession area, estate planning, long-term care planning, Medicaid, special needs planning, and estate and trust administration, and unfortunately, litigation. So these are the attorneys that do all of those things in our 2 offices. And our agenda, again, the importance of estate planning, the core documents, trusts, 21-22 changes, a little bit about charitable giving, long-term care, and then how you can take the information you learned tonight and most importantly, put it into action. Because learning about planning is good. Actually doing the planning is much, much better. So don't procrastinate, take what you learned tonight and get it done. Let's talk about the new world. COVID has changed everything. And as you might imagine, Columbia Memorial Hospital and all hospitals have faced enormous burdens during the pandemic. There are many heroes in our hospitals who have fought through very, very difficult circumstances, personally, their own health issues, family health issues, and caring for patients who have had COVID and come through the hospital, and those that haven't had COVID but needed the hospital during this critical time period. So we have been doing things differently in the practice of law, much more virtual meetings, consultations. I feel like I have 5 Zoom meetings a day, but we also meet in person and we do by telephone. So there is no barrier. We can work with people virtually. We do telephone consultations. We meet in person in our various offices. And so there is no hindrance to getting it done. The one caveat now that was different the last time I did this program is that we can't do virtual document signings. That was an executive order that lasted for pretty much the first half of COVID, but it expired in June. So now document signings, and in the law, when you're doing your estate plan, you can't use DocuSign, you can't use virtual signatures like many industries can. For legal documents, it has to be what they call a wet signature. So it has to be a meeting in person. We do nursing home doc signings, hospitals, drive-bys, where people literally come out to the car and sign things on the fly. And so there are ways to get it done. Don't let that be a hindrance, but we can always start the game with a virtual meeting and a Zoom to get things rolling. Why do it now? One of the big things in estate planning, people think, oh, it's an estate plan. When I die, what's going to happen? But as people age longer, and as we have the ability for medicine to keep us alive, but not necessarily keep us healthy for our entire lifetimes, we need people sometimes to make decisions on our behalf. And you don't want to be subject to a court process. We'll talk about that in a moment. You want to do the appointment right. You want to have the right person or people, and you want to get the documents done in a way that they're legally binding and that they're going to benefit you in the event that you do lose capacity. Just imagine COVID. If you had a severe case and you're in the hospital, you're on a ventilator, who's paying your bills? Who's managing your assets? Who's making sure that all of your financial obligations are being taken care of? And so we're going to talk about the legal documents, the financial documents, and the healthcare documents that are critical in an estate plan, in addition to things like a will that does take effect upon your death. So resolutions, we all make resolutions at the beginning of the year. I've already broken mine, so don't mind those. But resolve to get done the basic estate planning, and to get it done in a way that it's comprehensive, that you've covered your bases, and that the things that you may need in the future will be there at that time, at that critical juncture. So again, appointing individuals to handle various management of functions for you, financial, healthcare, making sure that your assets and your income are protected, looking at ways to put in place a plan, perhaps using a trust to preserve assets, to reduce taxes, to avoid creditors. And one of the things we'll talk about, avoid, again, court, the probate court and the surrogates court. And to provide a legacy. How does it go to the next generation in the best way possible? These are the core fundamental goals of estate planning. We're going to walk through all of them in this presentation. I am not a litigator anymore. I was once in my career, but I figured out it wasn't for me. I have a partner, Aaron Connor, who does most of the litigation in our Albany office. We have two partners in Manhattan that litigate in the city. And when I say litigate, we do trusts and estates. So we litigate inheritances, trusts, fiduciary accountings, all of those types of things, and guardianships. So if you don't have that planning done, if you don't have your power of attorney, your healthcare proxy, your trust, and you lose capacity, very often you end up in the Supreme Court in New York State, which isn't the highest court, it's the trial level, kind of backwards. But in Supreme Court, you do a guardianship and you petition, and it's a process that is tremendously, let's say, unnerving for the family. It's expensive, it's time consuming, and it's going to hang your laundry out in front of the judge and the public. It's a public proceeding in a way that you just never want to be in that seat, having family members having to come in and prove that you're incapacitated. So proper documentation can avoid that. And the probate court is in surrogates court in New York State. That's what they call it. And you have a surrogate in whatever county you live in New York. I think most of our listeners are from New York State. So you don't want to be in probate either, because now, especially with the pandemic, that's taking longer and longer to get through probate. In upstate counties, not as bad as down, but even up here now, you're looking at, just to get a will admitted to probate, 3, 4, 5 months. Downstate, 6 to 9 months in some counties. And the probate process is going to take a year, 2 years, 3 years to get through. You can avoid all of these things through proper planning. And why would you ever subject yourself or your family to being dragged through a court proceeding, which can be easily avoided? So getting planning done will avoid those courts. And we start with the core 4 documents, the things that, again, everyone should have. We start planning, and people ask this question often: at what age? When should I start doing a will? And for me to tell you when you should do the will, all you need to do is tell me the day you're going to die, and I'll have you come to my office the day before, and we'll be very efficient. We'll get it done. But no one knows that. No one knows when they're going to be incapacitated. And as we like to say in our firm, life happens. Be prepared. Well, these are the preparation documents. A power of attorney, healthcare proxy, operate while you're alive. The will and the disposition of remains appointment operate upon your passing. And together they provide you with substantial coverage for all of the issues that may arise. Let's start with the power of attorney. That's the financial document. And in this, you appoint an agent or agents. You can have co-agents under a power of attorney. So if you have 3 kids, you can name all 3. You can require that they act all together, unanimously, by majority, or you can allow them to act separately. So any one of the 3 could act on your behalf. Spouses very often name each other, and then the children as the alternates. But having a power of attorney, well-drafted, contingent agents, co-agents at times, is very, very important. And this law has changed in my career no less than 6 times. You think, oh, a power of attorney, very simple. Not anymore. In June, New York enacted a new statute, which now has very comprehensive provisions, and it replaced a statute that was badly broken. It's still a comprehensive document. And one of the things that you want to make sure is if you're using the power of attorney for estate planning, and you want your agent to be able to do the planning on your behalf if you lose capacity, you have to have what's called a gifting rider in the document. So I had a client come to me, his son, this was the son, the dad had lost capacity, was in a nursing home. The dad had about $1 million, and we were going to do some Medicaid planning and go to get things done. He said, oh, I have power of attorney for dad, no problem. Well, his power of attorney did not have the appropriate gifting power. So we actually, even though he had power of attorney, had to go to court and petition for the son to be appointed as the legal guardian of his father so that we could do planning to try to protect some of dad's assets from the costs of the nursing home. And the power of attorney needs to be done properly. Otherwise, you will end up in court. It's a durable power of attorney, so it survives your incapacity. And this is a document that's part of a standard estate plan that we do for every client. At what age should you have a power of attorney? We say 18. So when I sent my kids off to college and my kids had bank accounts and, oh, dad, can you put some money in my bank account? Well, gee, son, I don't have access to bank accounts in your name. But dad, you have my power of attorney. Oh, I did that, didn't I? So now I can put money in your account or take care of financial affairs or bills or things for your children, all the way up to when I'm power of attorney for my aunt who's 99. And it's a critical document to have in place when you need someone to make those financial decisions for you. Likewise, the healthcare proxy is a critical document. And there are a lot of different nuances to healthcare decision-making. A healthcare proxy is a statutory document. It's in the Public Health Law of New York, very simple, bare bones document. But is that enough? Should you do more? We believe that you should not only have the healthcare proxy, but also a living will or healthcare declaration that spells out your intentions with regard to healthcare and in particular, end-of-life decision-making. So the healthcare proxy combined with the living will, we do those in one document in our office. There are other documents that are available to people. One is a MOLST form, and many people now are looking at the MOLST, which is very detailed medical order. That's what it is, a medical order for life-sustaining treatment. You do that in conjunction with your healthcare provider. It's an excellent document. We love the MOLS for people that take the time to do them. Most people don't have a MOLS form, so we have the healthcare proxy and living will. One thing that is something you don't want to confuse is a DNR. A do not resuscitate order means that you have coded, your heart is stopped. Do you want extraordinary measures to bring you back? And that really depends upon what was your quality of life before you had the event. And if you could be brought back using the paddles, if you will, and you could be brought back to a state of being in which you were not only surviving, but thriving, you went back right to where you were pre-event, would you want to be brought back? And most people would say yes. And people come into our office all the time saying, I want a DNR. I say, I don't think you do. You want a living will. You want the power for someone to remove artificial life support if you're lingering and hanging on using artificial means. But if you can be brought back to a healthy state, you want to be brought back. Most people say yes. At some point, when you don't want to be brought back, then the DNR is appropriate, but just know the difference. We have in our office prepared a very comprehensive healthcare decision-making guide. And you'll see this is available on our website. If you go to the resources page, if you want to learn more about healthcare proxies, healthcare proxies, living wills, the MOLST, the DNR, and the history of it all, this is a complete document. It's very comprehensive. In New York State, covers every angle and avenue for you to make healthcare decisions and have surrogate healthcare decision makers. I commend it to your reading. The power of attorney is in our estate planning guide, also available on our website at the resources page. So those are the two documents that cover you during your lifetime. What happens when you die? Well, you have your property and you have your person. What happens to you? Your corpus, your body. And if you don't have anybody appointed, kind of is up for grabs. And this led to a lot of litigation in cases that resulted in legislation. In New York, about 12 years ago, we had a statute passed called the Disposition of Remains Appointment. You do a document, we call it a DORA for short, where you appoint agents, an agent to make decisions for you after you're gone about cremation, burial, funeral, church service, wake, all of the decisions that have to be made. And you put your detailed instructions in this document. It's legally binding, and it has really been, for some of my friends, a mitzvah, a gift to the family left behind, because it takes the angst away. They don't have to think, they don't have to worry. They know what your intentions were. And children come to me all the time, say, I never knew my father or my mother wanted that or didn't want that. This was a real saver for us. Oops, there we are. And so the disposition of remains appointment is the body part, and then, no pun intended, then the will is the property part. So this takes care of your assets. How do you leave things down to the next generation? Well, there are a lot of ways to do it, actually. If you have an IRA, it names a beneficiary. You can have joint owners on bank and brokerage accounts. You have life insurance, it has a beneficiary. For assets that are not owned that way, and where people kind of run into problems trying to do it that way, is when they own a piece of real estate, a home or other real property. That would go through your will. Individually owned assets go through your will. We call those probate assets. And your will is going to name an executor or executors. And again, you can have more than one person in that situation. If you have people you want to protect, maybe a disabled child or a spendthrift child, and you want to set up a trust, we have testamentary trusts that can be created through a will. We are going to appoint trustees to manage all of those trusts, provide for the orderly administration of your estate, the payment of debts and taxes. So a will is covering all of those situations after you're gone, dealing with every aspect of your property, your debts, your bills, your rights to other assets. All of that can be disposed of through a will. And that four-legged stool, if you will, the will, power of attorney, healthcare proxy, disposition of remains appointment, is a very inexpensive package. but it's something that everyone should have. You want it done comprehensively, you want it done right. And when you start this process, what's the first thing that you need to do? You need to take an inventory. What it is that you have, who it is that you have lined up to make all of these decisions on your behalf. Who are your family members? Who are your beneficiaries? So we have developed a questionnaire, again, available on our website. And this is an excellent place to begin this process because it's an inventory. It's going to help you to organize your thoughts, organize your information, gather up all the necessary documents and details. And this is where you would start, then have your consult with an estate planning attorney to take all of this information, have the conversation where you will discuss your goals and your intentions, and then to formulate a plan to carry out your estate. Maybe those 4 documents are enough, but one of the problems with a will is that by definition, it leads to a court process. I mentioned it earlier, it's probate. And we do probate all the time. It's fine for us because we're lawyers. What happens in probate? We get paid. We get paid to go to court because you can't go to court. Only we can represent others in a court process. And so we petition the court, you go through all the affidavits, all the proof, you have a citation date, you appear before the surrogate's court judge, and the judge then reviews the petition, the will, and all the other documentation, issues a court order, and gives the executor a certificate called letters testamentary. That's the authority from the court to act on behalf of the estate. How long does that process take? It used to be that you could get, in many counties in probate, get the will admitted, get an order, 30 days. But because things have backed up post-COVID, we're still digging out from that. And the courts are a bit overwhelmed and understaffed. So it's taking now several months to get the will admitted to probate, but that's only the beginning. That's just the authority of the executor to collect the assets, pay bills, make distributions, and then ultimately distribute the assets. And that's taking well over a year in most cases, sometimes 2. And as I said, if you have any issues in the estate, you have a disabled child, you have contests, people coming in and claiming things, that's going to take much, much, much longer. So there is an alternative to a will. It's called a living trust. And a trust does not have to go through probate. It can manage assets during your lifetime. It's a very secure way to do that. It can provide for successors to manage things, trustees who will have continuity of management. So they'll have authority if you're incapacitated. They'll have authority upon your death. And there's a continuity there that it doesn't break. And you say, okay, the power of attorney stops when I die. The will then has to go through the probate process, and there's a gap. Trusts don't have that gap. You have the ability to manage and deal with assets all the way through. So in order for the trust to be effective, you transfer assets in, retitle that real estate, put your bank accounts, brokerage accounts, other assets into the trust, and that can be a very effective tool to manage during your lifetime and upon your death. So we have many different flavors, like Baskin-Robbins, of trusts. And we use trusts for a variety of purposes. Living trusts, testamentary trusts, those are the ones created under the will. Revocable, irrevocable. We have specific trusts to own life insurance policies, to be beneficiaries of retirement accounts. Mentioned special needs. We do a lot of planning for special needs individuals. You want to have a special needs trust for that individual so they don't lose government benefits. We do trusts in other states like Delaware called dynasty trusts or family bank trusts, much more sophisticated and perpetual in duration. Asset protection is a big reason people want to do trust, tax reduction. And we're going to talk a little bit about beneficiary control trust, which is an easy way to provide substantial protection to the next generation. And a revocable living trust is a document you create during your lifetime. And it's something that allows you to transfer assets into a trust, manage that trust for yourself. So you are the trustee in this case, And it will also allow you then to have a successor trustee. So the successor will step in upon your incapacity or death and be able to manage on your behalf. What are the alternatives to a revocable living trust? Well, we talked about the power of attorney and a will. The power of attorney is during your lifetime. And I think we're back to the screen share. And the will takes effect upon your death. With the trust, you have one document that's going to allow you to transfer assets in. So you're called the grantor of the trust. You're going to be the trustee of that same trust. And you're going to be the beneficiary. So you wear all three hats in a trust relationship. Grantor transferring assets in, trustee managing assets, and the trust is there to benefit you. That changes only upon certain events happening. You become incapacitated. You now have a trustee who's going to step in on your behalf, who's going to manage for you and anyone else that's a dependent, and have the ability to manage those trust assets under terms that you set, still under your control. Upon your death, same scenario, successor trustees step in, and then it's going to go downstream to your other beneficiaries, your family, and other charitable or individual beneficiaries upon your passing. This avoids the probate court, and it's also a much better hedge against the guardianship court. And revocable living trusts have become the premier way for people to have a plan in place that they control, but that provides every contingency that they can to make sure that their assets are guarded and that they get to the right people at the right time, including themselves, in the event of incapacity. So what happens upon your death? And I have a revocable living trust for myself. My wife and I are the beneficiaries, and that all works really nicely. But when I die, I don't want all the assets that I've worked a lifetime for to simply pass to my kids, who may then get sued, get divorced, go bankrupt, have financial issues, or at some point have a health crisis where they need protection of assets. So is there a way that you can take that trust and extend it on to the next generation? And as they say, that's a rhetorical question, because I wouldn't have asked unless there's a solution. And the solution is called a beneficiary control trust. So BCTs, for our acronym, are trusts that you leave to the next generation or to someone else who you believe could otherwise manage things very nicely for themselves, but you want to give them a leg up. You want to give them the inheritance in a protected wrapper where they can be their own trustee. They can manage the trust on their own behalf. They can use the assets for themselves or for their families. But if they get sued, if they get married and they get divorced, they have those sharp divorce attorneys attacking the assets. They go bankrupt, or they have a health issue and they need Medicaid. The trust that you leave to them, even though they're managing the trust themselves, is creditor protected, divorce protected, Medicaid protected. So this trust is what I've set up for my kids. It gives me comfort to know that when they inherit, they'll have an ability to control that wealth, but have it free from risk for all of those other issues that could arise in their lives. So this is something that we have done more and more of. When parents hear the benefits, it's almost a no-brainer. This is something that you should consider if you have kids, even the best and brightest. The other part of this is if your children end up being wildly successful and they end up with an estate tax situation, the assets you leave in this trust are not includable in their estate. So it has tax benefits for them long-term if they are successful in their own careers. So let's talk a little bit about taxes. We have a whole myriad of taxes, and as I was writing this slide, I wanted the Beatles song to play, The Taxman. I don't know if you remember the Beatles song, The Taxman, but one of the lines is, if you want to walk, we'll tax your feet. Well, the government's out to tax everything that you have. And there are taxes on the transfer of wealth from one generation or one individual to another. So we have gift tax when you give it away during lifetime. We have estate tax when you give it away at death. And I'm not even going to talk about the other tax, which is when you skip a generation, called the generation skipping transfer tax. So everybody thinks that they can give something away during their lifetime. Some people still think it's $10,000, which is where it started. It's graduated up. And this year we had a little change. It went up from $15,000 to $16,000. So every individual can this year gift $16,000 to any individual, and they can do it in a way that they do it every year. So it's an annual gift that's free from the gift and estate tax system. If you're married, you can both give $16,000 or a split gift of $32,000 to any individual you choose. For families that have estate tax issues, gifting and using this annual exclusion is a great tool. But a lot of people misunderstand that annual exclusion, because in addition to the $16,000 per person per year annual exclusion gift, every individual also has a lifetime exemption. And for federal estate tax and gift tax purposes, the lifetime exemption is right now $12,060,000. So you could give $16,000 to everybody you want to, and then write another check for $12,060,000 and pay zero gift tax. If your estate ends up being under that $12,060,000, you pay no estate tax. And for federal purposes, most people are outside of that realm. And I have people with very modest estates coming in and wanting to make those $16,000 gifts. That's fine, but not for tax purposes. The other rule that kind of goes corollary to this, and we're going to talk a little bit about Medicaid later, that $16,000 free gift is only for taxes. It does not give you an exemption for Medicaid. And many of you know that there's a 5-year rule look back period. The $16,000 annual gift does not hold for Medicaid purposes. That's exclusively a tax provision. What if you get up above these levels? Well, there's a 40% tax now, and anything above that would be taxed at 40% federal. There's an additional New York State component. This whole scheme, this regime of a $12 million exemption is going to expire at the end of December in 2025. So 1/1/26, that $12 million exemption is going to be cut to $6 million, still a lot of money, but half of what it is today. So people with significant wealth are doing planning to utilize their $12 million lifetime exemption now. There are a variety of ways that we do that with our clients, but if you're in that situation, that's something that you need to consider. The rate is also going up back from 40 to 45% on 1/1/26. Well, what about New York, you ask? New York has an estate tax. The exemption is $6.2 million. But New York doesn't have any gift tax. So if you make that $12 million gift for federal gift and estate tax purposes, it doesn't generate any tax in New York either, even though the estate tax exemption is 6.2, because there's no gift tax. What New York does have is a 3-year clawback. So if you die within 3 years of making the gift, it comes back into your estate. So again, most of our clients don't have to worry about estate and gift tax, or what they used to call the death tax, to scare you. It's not in the realm if your estate is well under that $6 million figure. There are other things that we'll talk about that you do need to plan for. And of course, we are all still subject to income tax. And income tax, when we add up all the numbers, in New York, you have a federal top marginal rate of 37%. You have a New York rate that goes up to 10.9%, which is new last year. You have a New York City tax, for those of you down in the 5 boroughs, of an additional 3.6%. And if what you're being taxed on is investment income, There is an additional 3.8% investment income tax. So for a New York City resident, they can have income tax as high as 55.3%. And if you're not in New York, it's 32%. So it's a big number. It's a lot of money. And we face that on all types of ordinary income. That includes income from IRAs and 401ks. We're going to talk about a law change that happened in 2020 in just a moment that puts your IRA and your 401k in serious jeopardy from these exorbitant income tax rates. Capital gains tax hasn't changed, still 20%. They were fiddling with that with step up in basis rules. Nothing changed. The Build Back Better Act didn't pass. None of the proposals that President Biden had have gone through. So we still have a 20% tax on capital gains. If it's collectibles, and this includes things like NFTs, non-fungible tokens, the new art, if you will, those are taxed at a higher rate of 28%. Again, you have New York State tax. New York doesn't distinguish capital gains from ordinary income. So you have a New York State tax.  City, if you're in New York City, you have an additional tax, the same net investment income tax. So even capital gains can get up to 35 to 38% tax. So when you're looking at your tax picture, you have to factor in income tax, capital gains tax, gift tax, estate tax, and it becomes very complicated. So usually for clients who have these kinds of tax issues, we work as a team with your CPA, with your financial advisor, with us as tax counsel, and prepare a plan that helps to reduce the ultimate tax burden. We are still in a very low interest rate environment. And I just put this slide up for fun. These are all of the different types of trusts that we use in the tax planning realm. Not going to talk about all of them. We talk about one or two, but suffice it to say that in the estate planner's toolbox, there are tools that are trusts that allow you to maintain control of your assets, access to your assets, and achieve the tax planning goals that you're looking to achieve. But charitable giving is something that's often overlooked, and it can help you in every tax realm that I just mentioned. It can help you with capital gains tax, can help you with income tax, with gift tax and estate tax. And so charitable giving is something that we use in our estate planning, and it's something that we're going to just touch on briefly right now, because if you don't use charities and you have taxable situations, whether it's gift, estate, income, capital gains, you have capital. You have personal capital and you have social capital. And your choice is you can either keep your personal capital and give your social capital to the government, who I assure you will spend it wisely in their policies and in their doling out of the tax revenues that you provide them. That's one form of social capital through taxes. The other is philanthropy, charitable giving. And that's voluntary social capital, where you are taking money and leaving it to charitable purposes, which many of our most wealthy individuals, Warren Buffett, Bill Gates, they all have very, very extensive charitable plans, foundations, charitable trusts. And it's a way that you can reduce your own income tax burden, reduce capital gains tax burdens, reduce your estate tax, and provide for community, provide for those groups and organizations like the Columbia Memorial Health Foundation that give back to the community. So some smart charitable techniques, and some of these are very simple. The government allows you to give directly from an IRA or retirement account, 401k, if you're over the required minimum age of 70 and a half, you can give to a charity $100,000 per year, and it never hits your income tax return. It is a completely tax-free gift. It's an excellent way, doesn't count toward any of your other income limit type programs, Social Security, Medicare, et cetera. Comes right out of your retirement account. And remember that 50+% income tax bracket. When you leave that $100,000 to a charity, they don't split that dollar bill. They get the whole dollar. They are tax exempt. So it's a way that you can reduce an otherwise very tax hostile asset, like an IRA, which is 100% income taxable, and benefit your community, your hospital, and the foundation. Highly appreciated stock, if you've been fortunate enough to invest in certain stocks that have built up over time. You listened to Kramer 15 years ago and you bought Apple, and you've held Apple for this whole time. So you've got a very low basis, and Apple is split umpteen times. We have clients that have held on to Apple and have huge capital gains. Well, when you want to give to a charity, do you write a check out of your checkbook, or do you give a share of highly appreciated stock? If you write a check out of your checkbook, you're giving them $1 after tax. If you sell your stock, you're losing 30% plus to capital gains. So you're going to keep 70 cents of that dollar. But if you give the stock to the charity again, they get the whole dollar. So using highly appreciated assets to donate to charity is an excellent way to reduce your own capital gains tax burden, get a deduction, and the charity gets the full value of that stock when they sell it. You can, upon death, name a charity as the beneficiary of an IRA. And this is something we tell clients all the time. They'll come in and they'll say, well, I have the charities in my will and I'm leaving, 100,000, 200, a million, whatever it is, to the charities. And okay, you have IRAs. Yeah, where are the IRAs going? They're going to the kids. Well, re-engineer that. Leave the IRA to the charity, which gets 100% of those dollars, and leave the other assets to your family and your direct individual beneficiaries, because they're going to get 100 cents of those dollars, because even if there's capital gains in those assets, they're going to get a step up in basis upon death and be able to sell those appreciated assets free of tax. So just cross-wire it. Retirement account assets, think charity. If you're going to give money to charity, that's the best asset you can leave. And leave the other assets to the individuals, because they can get those with a stepped up basis and inherit them tax-free. And when you get to the next level, those are just things that can be done directly with your advisors, leaving the IRA during lifetime, the IRA at death, gifting charitable, highly appreciated stock to charities. But when it comes to the charitable trusts, you need a little bit more comprehensive planning. And those are things that we do. And I mentioned the Secure Act. So I'm going to combine two ideas here and give you a little thought that when people inherit from you an IRA, they now have to draw that IRA down over a 10-year time period. So that's going to add significantly to their income tax burden. And the purpose of this, from the government's perspective, is there are estimated to be $12 trillion in retirement accounts right now. And people were figuring out ways to stretch out the benefits so that the income tax burden was delayed for the government. So this was something done by President Trump in 2020, took effect on January 1 of 2020. And now, instead of being able to stretch the IRA, you have to pay your tax over 10 years for the beneficiaries. So that leads to a significant increase in their income tax burden, and it's going to reduce the ultimate benefit to your heirs from that retirement account. So remember that array of trusts? One of the trusts on that list was called the Charitable Remainder Trust. So these have become now very popular tools for people who want to benefit their family, but also want to benefit charity. They're called split interest trusts. And in a charitable remainder trust, it's just that. The charity gets the money someday when the income beneficiaries are finished with it. So we've used charitable trusts. I've been using them my whole career. They're very useful tools. For retirement plans, what you can do is create the trust, but don't fund it. You then name the trust as the beneficiary of your IRA. When the IRA hits the charitable trust, it's like a charity tax exempt. So 100 cents on a dollar goes into the charitable trust. It then gets reinvested by the trustee, which could be your beneficiary. Let's say it's a child. Your child can reinvest that money, and the child then gets an income stream. Depending upon their age, it could either be for a lifetime or for a 20-year term. And at the end of the day, they get more money out of the retirement funds than they would have having to take it out over the 10 years and pay the tax. There's financial modeling that we do for these, but it's an excellent way if your estate is skewed towards retirement funds, 401ks, 457s, 403bs, IRAs. This is an excellent way that you can provide a significant income stream from those assets to your family and still benefit your charity, your favorite charity, long term. So the CRT, or Charitable Remainder Trust for retirement benefits, is very in vogue right now, something a lot of people are learning about and utilizing, and we've utilized them for years, something that is very, very beneficial to you, to your family, and to your community, because you can buoy up those organizations that provide the support to your community. All right, for the last 10 minutes, we're going to shift gears. And the gear shift is going to go from tax and estate planning to something we refer to as long-term care planning. And if you look at the statistic on the right, 70% of people age 65 or older are going to need long-term care at some point in their life. And their lives are longer now. People are staying alive. Medicine keeps us going, keeps our heart ticking, but doesn't necessarily mean we don't need some help in those later years. And that's called long-term care. Long-term care can be in home, it can be in an assisted living, it can be in a nursing home, but the costs of long-term care have escalated to the point where most people can't afford a prolonged long-term care stay. So unfortunately, contrary to popular belief, Medicare does not cover anything in the long-term care realm. Social Security is Social Security. The only program that does pay is Medicaid from a public perspective. So do you consider long-term care insurance? Not many people are buying that today. Policies are limited, but they're still there, and it's a good hedge in defending against the need for long-term care and preserving your income and your assets. Planning for long-term care is essential now as a part of retirement planning and estate planning, whether you're privately insuring. If you're fortunate enough to have income that can pay $200,000 a year without putting a dent in your assets, then maybe you're self-insured. But many people rely on the Medicaid program. And Medicaid is divided into two pieces. You have institutional Medicaid or nursing home Medicaid called chronic care. There's a 5-year look back for that. And then you have community-based Medicaid, where people can actually get home health care financed under the Medicaid program. And in New York, that's been the rule for many, many years, unlike many other states. This is somewhat unique to New York. Current budget cuts have put a little bit of a crimp in Medicaid, and we have new rules coming into play that are going to be taking effect. Some took effect in November. Others have been put off due to COVID to next year. But when we sit down with clients and they're doing retirement planning, you have to ask yourself, if you did need care, where would you want to be? Where would you want to be taken care of? Do you own a home? Do you want to go to an independent living center? Would you be okay with a group congregate housing like assisted living or nursing home? Most people would say they want to be independent. If you want to be independent, that means you're going to be at home. The next question is, who's going to take care of you? And that's a big question today because there's a shortage of labor out there in the whole labor market, but in particular, healthcare, and even more in particular, home health care. Home health aides are hard to find, but they're still there and can be found. You need to have a payment source. So the next question is, how would you pay for care if you needed it? And that's where we come to self-insuring. I can pay out of my own pocket. $180,000 a year is the average nursing home cost in the Capital District right now. Or I can privately insure it. I can buy a long-term care or life insurance policy. They have life insurance now with a rider that allows you to use the benefit for long-term care purposes. If you can't self-insure and you don't have private insurance, then Medicaid is the only other game in town. So we look at Medicaid as a resource, and we plan to get Medicaid in place if and when the need arises. And that's part of the planning that we do now in conjunction with retirement planning. Columbia Memorial Hospital is innovative in this area. And I'm very happy to say that they're participating in a pilot program with the Home for the Aged and other Columbia County organizations. And it's organized through a new not-for-profit, Everhome Columbia, Inc. And this is where healthcare is going, creating virtual homes for the aged, in this case in Columbia County, but this is intended to be a pilot that ultimately goes nationwide. And Columbia Memorial is doing more community outreach, working with the homes of people, in the homes of people, to keep them at home and use state-of-the-art technology and case management to bring people services in the home that allow them to age in place. If they can't afford those services, then Medicaid planning becomes part of the game. And we use a trust. I mentioned revocable trusts earlier. Irrevocable trusts are available to help shelter assets, and you can put assets in, you can keep the income, but this protects the assets and allows you to keep a base of assets during your lifetime and still utilize Medicaid to pay for that home care. Into the trust would go your home, bank accounts, stocks, bonds, annuities, life insurance, businesses, real estate. And the income comes back, the principal stays in, but if you have family members like children, they could actually draw that principal out. This has been around for 30 years plus, and it's a trust that we utilize very frequently for people as they're aging, looking at retirement, wanting to shelter assets. This is the way that that happens. One thing to note is that in New York State, IRAs and 401ks are already exempt. They give you that protection. So you can keep your IRA, 401k, put other assets in the trust, and create Medicaid eligibility. And for home care, that happens very quickly. If you have other questions on long-term care or long-term care planning, you can find more information on our website at pierrolaw.com. We have a series coming up of Medicaid seminars. If you're interested, you can always get future seminar information on our website as well. So it's a lot of information. One of the keys is getting out in front of this and not being reactive, but be proactive. Don't procrastinate. Don't let inertia stop you from getting your planning done. Get that questionnaire, download it off our website, or you can email us and we'll provide that to you, info@pierrolaw.com. Get your process started to make sure that you're protecting yourself, your family, and your hard-earned assets. Informed planning takes a team. We very often, again, work with your accountant, your financial advisor. And when this plan is done in a comprehensive way, it puts in place for you something that will give you peace of mind. And if you can work your foundation in and support the community foundations and the Columbia Memorial Health Foundation, those are things that will stand your heirs in good stead, because guess what? They may need that hospital someday too. So with that, that's us. And we have appointments available if you'd like to discuss your estate planning in Hudson by appointment, in Albany, New York City. And we'd be happy to talk to you. We do offer a free consultation for attending, and thank you for being with us tonight. And if you're ever looking for something to do on a Saturday morning at 11 a.m., we have a radio show. It's called Life Happens. Are You Prepared? On WGY. It's also available on iHeartRadio. And we cover a lot of topics like financial planning, estate planning, tax planning, long-term care planning, and it's a call-in show. So it stays lively, and we hope you can join us some point on a Saturday morning at 11. With that, I would like to thank the CMH Foundation and Barbara and Jim personally, and also thank you for being with us tonight. And hopefully the hour has been meaningful and you could take something away. But if you take anything away, just do it. Don't let it get you. just get it done.